Okay, go for it.
Perfect. Hey, good morning, everyone. I'm Chris Parker. This is Kristen Ishihara with the Ishihara and Parker Law Firm here in Longview, Texas. And today we are talking about one of the topics we see a whole bunch. Do I have to leave my children $1? Do I have to leave my child an inheritance? And obviously families are complicated. Kristen, what are we talking about? What are we seeing here?
The short answer is no, but please do watch through the rest of the video. There's a lot of misinformation out there about, if I have an estranged child or I have a child that's maybe going through some issues or for whatever reason, it truly doesn't matter. Maybe they're well off and you have another child who needs the money. Doesn't matter. In Texas, you have the right to create a will that leaves your stuff to whoever you want at time of death. It does not require that they be related to you. It does not require that you do equal shares to children. It does not require that you include anybody at all. You can have a spouse and 3 kids, and you can leave everything to your neighbor. You can leave it to whoever you want. There is no right to inherit as a child. That is not true in all states, but in Texas, you have the absolute right to create a plan, an estate plan that leaves stuff to whoever you want. And a lot of times we hear the title, which is... Go for it.
The title?
Yeah. What do people think they have to do?
Oh, yeah, of course. They come in all the time and say, hey, I was told I have to leave my child $1. Or they bring me a will that says, Todd gets $1, Sarah gets $1, and Sally gets everything else. And I always ask, what is the plan behind this? Were we really trying to deliver $1? Because because there's ramifications, right, Kristen?
Lots of ramifications.
Why would we consider not leaving $1?
Sure. So if the point is to not include a child, you don't want them to get anything substantial from your estate, you've actually created a really big problem by listing them to receive $1. So if I have 3 kids and my will says leave Sally $1, split everything else equally between Bruce and Brian, let's say Bruce is my executor. When he goes to probate my will, because I've left Sally $1, he has to notify her through the proper channels, which require giving notification to anyone listed as a beneficiary in my will. So I have made my executor create a legal proceeding because he's probating the will. So there is an open legal proceeding. I've made him notify the kid that I really intended to leave nothing and insulted Sally by saying, I'm leaving you $1 when I'm leaving everything else to everybody else. So she has access to the copy of my will where I've said I only want her to get $1 and what I'm doing with everything else. And then in that public proceeding, the probate, I have to file an inventory that says what is in the estate. So Sally has open ability to see all of that information. She probably has an incentive to come try and challenge that distribution. She has no downside. But I've required that a legal proceeding be set up that we kick Sally when she's down by saying, hey, you're a beneficiary, but not really.
Yep.
And
there you go. You just raised the cost of probate, the stress on the person you're trying to give it to, really for no purpose at all.
Correct. What's the alternative?
Yeah, and so the way I usually do it, and there's different ways to handle it, but of course you identify your family correctly. I am Sue. I have these 3 children. My personal preference is to say I've got a child named Sally, and Sally is excluded, or Sally and her descendants are excluded. Now, I have a lot of parents who come in and say, oh, Chris, I am mad at Sally, and I don't want her to get anything, but golly, I just can't put that in writing. Instead, I'd like to list the children correctly, and then not say they're excluded, but simply name the people it goes to. Now, that's not my favorite, but I'm not the parent, all right? These are tough emotional decisions. I'd prefer the document be crystal clear. I have this person is out, them and their descendants are excluded. That's perfect. I have other people who say, Chris, I don't mind bypassing Sally, but goodness gracious, I can't put down that she's excluded. Instead, I just want to list the people it's going to. Obviously, I work for the client, but these are hard, but they're very doable, and adding a beneficiary that is not supposed to be there, I think is a mistake.
Absolutely. Our specific advice would be to specifically disinherit them would be the right legal language to include in there. But as Chris mentioned, some people are uncomfortable with that. What you don't want to do is explain in the will. So no explanation. You are not including words. Why? Because that allows that child to argue something. So if I say, I'm not including Sally because she's married to Joe and I don't like Joe. Well, maybe she's no longer married to Joe. So I've included a reason that she could come contest your will.
Or I've already provided for her in other ways. Yet it turns out those other ways went away when you lost that life insurance.
Right. Right.
Just-
Don't create arguments by including additional information.
Yeah.
You provide only the necessary language and no more. One other thing that is an option that sometimes people will consider or include is perhaps we don't want to leave Sally $1. We do really want to leave her something. Maybe we leave Sally $25,000 and then everything else between Bruce and Brian. And in that, you would want to include in your will, which is standard in all of our stuff, but a good idea, it's called a contest clause. So it says, I've made Sally a beneficiary. If any beneficiary complains about what I've left them, I want them to get cut out and I want them to receive nothing. So that doesn't work if it's $1, right? Because the incentive is not great enough. But if you make the bequest to Sally great enough that she might read that and say, well, I don't want to lose $25,000. Maybe I'll just take it and be okay. Sometimes people choose to do that as well.
Yeah, and another form of estate planning, I've had, say you're a blended family, husband and wife been married for a long time, but husband had a son from before marriage. Maybe he does have a good relationship with that son, but he doesn't want to complicate his wife's estate plan since we know she'll have to probate because it's a blended family. So I've seen before where he will get a life insurance policy or open up a checking account and put funds in there and say, hey, I'm going to use these funds, they're mine, but whatever is in that checking account would go to my son, if anything. And so basically that's outside the will planning. Like he is going to exclude his son from that will, or at least a name and then bypass, but then he's not really not wanting to get anything. He just doesn't want to be part of the probate process involving his wife.
Right.
And so that's something to think about. It's just you have to understand that it can get complicated, and we want you to make sure you're doing it with intent, not mistake. I've seen so many people show up like, well, I got this and she got that, but the will says this, and no one has any idea, and it was clear that the testator was just sort of throwing darts at a wall, right? You want your plan to make sense to you. It may not make sense to everyone else, but I want you to do it with intent, not mistake or accident.
Right. One thing that usually folks want to consider when they're doing that is, so in my scenario, I named Bruce as the executor, I think. So Bruce's job then is to reach out to Sally to make her the beneficiary. Well, maybe they don't have a good relationship,
right,
because Sally's been estranged for a long time. So you are requiring that your executor is the fiduciary, handle all beneficiaries that you've named in your will. So sometimes people do, just as Chris has expressed, list Sally as a beneficiary of a specific asset, but leave her out of the will so as to acknowledge that your executor may not have the ability or relationship where that would be a helpful thing. That might create conflict when you didn't intend it to do that.
Missing children. I've had many folks who are like, hey, I haven't had contact with my child in 20 years. Well, that would be somebody you want to exclude, not put $1. Don't put a burden on that executor to try to figure out handling a miss. If you can't find them for 20 years, they're not going to have any luck either.
Right. You may well want to say, I want everything to split equally, but someone has to make that split happen. It's your executor. You're naming your good kid probably to be that executor. Is the burden that you're leaving on them fair when those other kids may or may not be involved or may be difficult for them as well, just like they've been during your lifetime? So just making sure you understand what you're asking your executor to do is important in our opinion. Anything else you want to add on that?
Just a side part of this, if you are excluding someone, if you have someone you are bypassing, either specifically cutting them out, which I like, or if because mom and dad are emotional, just want them named but skipped, remember that executor is going to need the original will. They're going to need the original will, because in these kind of cases, everything that's not perfect is a problem, and they have to show up with a copy, and you're excluding someone, things are going to get a little messy.
Sure. And also, we've done videos, of course, on trust as well. This would be a good plug to say you might be in a situation where you might want to consider a trust and funding that, as it's more private than a probate proceeding as well. So check those videos out. And I think that's all we have for today. Thanks for being with us.
That was a good one.
Yeah.
I think that's a good one.
Yeah. Uh-oh.
Where's that going?